Hi, this is Dr. Cora Stack here. This is a piece of work that has been, something that I've been studying for many years, and I just want to talk about it now because I think it's important that the public know about this. Acts of omission, very difficult concept. How Ireland's whistleblower law failed its promise, 2014-2022, by myself. So, in 2014, Ireland introduced one of the world's most progressive whistleblower protection laws, promised to protect truth-tellers to make wrongdoing visible. But as my investigation revealed, between 2014 and 2018, the Act's strength was quietly dismantled, not by open opposition, but by omission. The Protective Disclosures Act 2014 was hailed internationally, aligned with OECD and EU principles. It promised protection for anyone reporting wrongdoing, from criminal acts to misuse of public funds. Most importantly, Section 8 established a crucial safeguard. A disclosure was protected unless proven otherwise. To the contrary, that means in court proceedings. On paper, it was one of Europe's stronger procedural frames, so it's protected unless proven to the contrary in proceedings, which means by a court. But in practice, the Act's power was neutralised. Across Irish universities, institutes, government departments, and all public bodies, one vital clause was missing in many. The Section 8 presumption, its omission, shifted the burden of proof back onto the worker, the very opposite of what the law intended. These were not mere oversights, they were acts of omission, failures to act when duty required, failures to represent the law faithfully. So this is an extremely important video. Omissions are not passive, they're active instrument of silencing. For those who spoke up, the consequences were devastating: bullying, marginalisation, reputational harm. Internal investigations became biased quasi-legal processes. Legal advisors, often funded by the state, reinforced institutional self-protection. Public to taxation or the cost of compensation, while governments remained unchanged. In 2022, reform arrived. The EU Whistleblowing Directive compelled Ireland to amend its law. The new Act reversed the burden of proof, expanding protection, and created the Office of the Protective Disclosures Commissioner. Sounds good. For the first time, omissions themselves were recognised as potential wrongdoing, a critical advance. The questions, again, actually they were in the original it was that omission, but questions remain. Are institutions truly compliant? Has culture changed? Or have we really transformed reform without transformation? Omissions are not just actions unperformed, they're absences that distort truth. That sounds like narcissism, doesn't it? Distortion of reality. That's very much what a narcissistic individual does, or sociopathic. In policy documents, reports, omissions can conceal accountability. 2022 reforms finally recognised that silence itself can be a form of wrongdoing. Ireland's experience of a lesson to every democracy: legislation without faithful implementation is an illusion. Protecting whistleblowers requires courage, oversight and culture, and not just compliance. As I concluded in 2018, rights can be lost not to denial, but to omission. And unless omission itself is recognised, which it was, silence remained our greatest failure. Now, the key issue here is what happened to the legislation under the establishment of the role of the Commissioner, which is what I found out during the election campaign, that in fact the role of the Commissioner substantially even kind of appeared like it was improving the powers of protective measures, but in fact it considerably diluted it, and it was only going around the election campaign that I spotted the flaw, and that was that the Commissioner could not refer any protective disclosure to the court, particularly ones that couldn't be referred to anywhere else, and they would involve constitutional issues, which was exactly what my paper was about. It was about all of the acts of omission in the alleged implementation across, doing a study of all the, all the internal protective whistleblowing policies of practically every county council, every university, every public body. I mean, it was widespread. And then I just benchmarked it. So it was very much like my work on Project Mass. I did an international kind of a national benchmarking, and I could see what happened then was devastating for whistleblowers, because matters of a constitutional nature had to be taken by the person rather than the state. The burden was switched from the state to the individual person, meaning that a whistleblower would have to take on the power and might of the state to expose wrongdoing, particularly of a constitutional matter. Now, it also transpires from our research that this legislation, allegedly, there is no evidence that this broad legislation, which considerably diluted the powers of the original Act under the establishment of the Commissioner, which could not transfer any protective disclosure to the state, to the courts, was not referred for examination to the Supreme Court. So the courts were effectively removed from oversight of an extremely important bill for democracy, the whistleblower legislation. So we were all conned, inverted commas, by this new, very weak legislation, which, as a result of what happened, made the strongest whistleblowing law in Ireland the weakest, one in the world, the weakest in the world. And it's disgraceful in the extreme that this was not transferred to the Supreme Court with an oversight. I know they have a lot of work to do, but this was far more important than any other work they would have been asked to do in the last 50, 60 years, and yet it wasn't referred. As I understand it, there is no evidence, and that was the big shock that I found going around. And then I tried to invoke the Protective Disclosures Act in order to expose all of this carry on, with the blocking and all of that carry on and I found out very quickly that I couldn't do it. And why couldn't I do it? Because it wasn't allowed under the amendment headed up by Malcolm McGrath and advised obviously by very senior solicitors, who I'm sure we'll see pretty shortly. So it's absolutely reprehensible thing to do, to subversion of the courts, in my opinion, and particularly the Supreme Court, from any kind of oversight of the Protective Disclosures Act, and putting all the burden on the whistleblower. It is absolutely reprehensible, and what strikes me as very coincidental is that I was the person that actually wrote the paper which disallowed all the acts of omission in the original. It was one of the, what I've said there isn't quite accurate. It was one of the acts of irrelevant wrongdoing, and the thing about it is it was all skewed to make sure that someone like me would never enter a presidential race. Isn't that absolutely reprehensible? You wouldn't make up the script. You could not make up the script. It's absolutely reprehensible. And as I say, I've been under surveillance, allegedly, for a long time. No wonder they didn't want me to go, because they didn't want anyone to find out about to bring this acts of omission, which unfortunately would have proven that a lot of all the bodies and all the governance, all these governing bodies of all these places were behaving in an unlawful manner in many cases, by saying that they're doing a little better now. But still, the key point is that many protected disclosures, particularly the constitutional ones, can't be investigated, and many of them can't be investigated because there's no jurisdiction. And you'd imagine those ones would have to be transferred, particularly this one. And it would have shown, of course, that it was unlawful and unconstitutional. So it's extremely serious what I'm doing. And you couldn't make up the script. The one who's going for the president is the one who exposed all the wrongdoing. Is it any wonder they had me under surveillance, allegedly? Very serious surveillance for a long time, and all this blocking. I can tell you they blocked me in many, many ways. But and they'll do it tomorrow, adjourn, appeal, every kind of a block that these solicitors do. Well, let them show their faces. And the solicitors that turn up tomorrow, I can tell you, they are allegedly corrupt, allegedly, because they were the people that did the dirt on the Irish people with the establishment of this super smart idea of establishing a commissioner with no powers, and which subverted the Irish court system, in particular the Supreme Court, from the oversight of the Protective Disclosures Act, of egregious corruption, allegedly, and the government should be made accountable. But I'm saying we need a new system of law. We need to move to arbitration, for the betterment of society, rather than making everybody unlawful or anything like that. That, I think, has to be a new system of law, with a layer called Arbitration First, and I've written 3 papers on it, and it's up on academia.edu if anybody wants to have a look at it, and I've had other papers as well over the last year on public policy and every other kind of policy. So I know what I'm talking about. There's nobody in the presidential race that knows more about constitutional law than me. And why is that? I don't know, because I did this protected disclosure tax. So who were they really trying to block? Was it all the other ones, or was it me? Well, time will tell. So, disgraceful to carry on by, well, again, it's not the rotten apple, it's the rotten barrel. So if we take the legal system as the rotten barrel, allegedly, we've got to change it, or we've got to do something about it. So that's my position, and thank you very much for listening, and we're all excited about who's going to turn up tomorrow and what tactics they'll have. There's nothing clean when you're dealing with these kind of solicitors, allegedly. Nothing clean. Every tactic, every trick in the book they'll have. So don't worry, they have plenty of things in their pocket. They have plenty of tactics in their pocket. I'm only illiterate, trying to figure out what their game is. And their game is to make sure that case does not go ahead and adjourn, or appeal, and that'll all wear the opposition down. That's their game. And anything they can get on you, they will use against you. So it's absolutely despicable. The amount of surveillance, the amount of harassment I've had to endure for many years is absolutely despicable, and the extreme.